seek your lordship's indulgence in making a mention, my lord, of item number 15, hearing, my lord. If this matter may come up after a week, my lord, this is listed for the first time for hearing, my lord. Item number 14, my lord, we are going to have.
You're
It's a
appointed
bit
as
lengthy
the
matter,
amicus? No.
It's a bit lengthy matter, my lord.
Oh.
Matter involving human trafficking and so.
Are you the amicus here?
No,
or
my lord.
Okay.
Item number 15, I am for the appellant, my lord.
For the appellant, so counsel for the appellant is swearing will allow, isn't it? You heard Mr. Saurabh Pradhan, learned counsel for the appellant, who has prayed for adjournment of the matter, which is not objected by Mrs. Linda L. Fumble, learned public prosecutor for the state respondent. In view of the above list, after the ensuing vacation.
Mark.
Seek lordship indulgence in mentioning item number 16, hearing, my lord. My lord, since my senior is on leave this week, and if the matter may be listed after the vacation, my lord.
He's as the amicus or
He's for the appellant, my lord.
appellant. Mention is made on behalf of Mr. Johnny L. Tolson, learned counsel for the appellant, for adjournment of the matter, again, which is not objected by, then one is additional will be. List after the ensuing vacations in view of.
Admission, item 1.
Yes, Your Lordship. In this regard, I was instructed to file the affidavit.
Yes.
And Your Lordship, I'm going to file my affidavit today.
The rules are ready,
Yes, Your
Human
Lordship,
Rights
it's
Commission
ready.
rules. Then when do you think you'll be able to have the Human Rights Commission functional?
Regarding that, Your Lordship, I have to take instruction when it will be ready.
Yes, Miss Rosalind L. will give me time. Miss Rosalind Elma, learned counsel for the petitioner, is present, along with Miss Vanna Isyami, learned government advocate for the state respondents. The learned government advocate submits that she will be filing the affidavit incorporating the Mizoram State Human Rights Commission rules within the course of the day. In view of the above, is the matter in the next week or after the vacation?
After vacation.
After the ensuing vacations.
Obliged.
Item 2.
My lord, in item 2, I'm still awaiting some documents for filing additional affidavit in this regard. If I may be given 2 weeks' time, my lord.
What is the matter about?
It's jail infrastructure. The
Jail.
construction is going on, my lord.
So we want the up-to-date status
yes.
of what's going on, isn't
Yes,
it?
madam.
Because 36.30 crores was released way back last year. 29/04/2024. So by now, a lot of developments have
Yes, my
should
lord.
be there.
Developments are still going on. So if I may be granted 2 weeks' time, my lord, I'll try to file my additional affidavit.
You will grant it, right? Ms. Rosalind Elmar, learned counsel for the petitioner, is present, along with Mrs. Linda L. Fumble, learned additional AG for the state respondents. The learned additional AG has prayed for further time to file the affidavit, highlighting the present, highlighting the up-to-date status regarding the construction/renovation of the central jail and the other 7 district jails. Full stop. She has prayed. No, full stop. Then, in view of the above, new para. This the matter again after 2 weeks.
After 2 weeks, my lord.
Yes, Ms. Zarim Sampo, you're there in this case? In the presence of Ms. Zarim Sampo, learned CGC, for the respondent's number, you're what?
7.
Respondent number 7 is noted, yes.
Online.
Item 3.
It is Your Lordship. Your Lordship, we have received the additional affidavit filed by the petitioner on 16/9/2025, wherein they have made a statement that there is some diversion of funds.
Funds,
So with that regards, if I may be given time to obtain instructions, Your Lordship, because I
What
do not
about the
have.
road condition?
It's been annexed,
This is,
my lord.
this is
Annexed
the
to-
road, isn't it? This,
Yes.
it's concerning the road, isn't it?
Yes, Lunglei Road
Lunglei
construction.
Road, huh. He has enclosed some photographs,
Annexed to, my lord.
press release. And then there's also an extra tree. This is first report on Aizol Thengzol Lunglei Road. Have you looked at this report?
I did, yes, Your Lordship, but I do not have the answer for that. That is why I need the time for obtaining instructions.
If I'm not mistaken, till date, people are preferring to use the other road via Setchi. And it appears that huge amount of money has been sanctioned. Anyways, by the next court date to find out, what we are anticipating is that after the monsoons, which is now slowly receding,
Yes.
there would be marked improvement
Yes, yes.
regarding that stretch of road. Because the usual excuse that is given is because of the
Monsoon.
monsoons, the condition, they cannot work, isn't it? But now the weather is improving, except for last night thunderstorm. During the daytime, they can work. So we'll list this after some time, and by the time the affidavit is filed, we expect some notable improvements over that stretch of road, and also see how the amount of money has been spent, whether it's actually diverted, and even if it was diverted, for what purpose, and is it going to be replaced? Because we cannot ignore this stretch of
Duly
land,
noted, Your Lordship.
isn't it? Yes, Mr. Laloko Mapautu, Learned Counsel for the petitioner, is present, along with Ms. Mary L. Kiante, Learned Additional Government Advocate, Learned Government Advocate for the state respondents. It is seen that the petitioner has filed the additional affidavit enclosing certain photographs annexed as annexure 2, wherein the present status of the stretch of road, that is Aizol, Thengzol Lunglei Road. First off, we have perused the photographs enclosed and finds that the roads are still very much in need of proper maintenance and repair. It is also seen that the affidavit has also mentioned at para, which para is that? Diversion of money?
My lord. Page 5, my lord.
Yes, at that has mentioned
In para 7, as well as 8.
as follows. Okay, so we will mention that para wherein so we will reproduce para 7, and para 7 I think is enough.
Okay.
It is also seen that the additional affidavit has also enclosed the first report on Aizol Thengzol Lunglei World Bank Road, published by the Mizoram Legislative Assembly Secretary, which is a report given by the Committee on Estimates. What's the name of the committee? Committee on Estimates, is it?
Yes, madam. 2024 to 26.
Regarding the Aizol Thengzol Lunglei World Bank Road. The committee at chapter 4, Roman 4, has given its summary and recommendations regarding the improvement and the maintenance of the said stretch of road. In view of the additional affidavit filed by the learned counsel for the petitioner, the state respondents are to respond to the report made by the Committee on Estimates, and also addressed the point concerning the allegation that funds have been diverted for other projects, the funds which were meant for the repair of the Aizol Thengzol Lunglei Road have been diverted. Full stop. The state respondents are also to highlight as to how the funds which are as to how the sanctioned amount of 58 crores 99 lakhs sanctioned letter dated 30 April 2025 are utilized for the said Aizol Thengzol Lunglei Road. Okay. List the matter. Anything else? List the matter after 3 weeks. Okay, for the state respondents to address all the said to address the said allegations or the said observations made in the said report. Yes.
Deeply aware.
List after 3 weeks will be enough.
Your Worship, 4 weeks at least.
List after 4 weeks. We have also observed that since the monsoon season is now receding, significant improvement will be noticed over the said Aizol Thengzol Lunglei Road. Yes.
Batch.
Item 4.
Yes. Again, road.
Yes, Lordship.
This is Aizol Coliseum, Silchar.
There are 4 stretches of road which we have highlighted, Lordship. In the meantime, if I may be allowed to file another additional affidavit, which also concerns the road already mentioned in PIL 1 of 2025, Lordship. It is on the photographs are on page 116, 123, 124, and 127. This is also taken up by NHIDCL Kolkul to Liapui Road, Lordship, which needs intervention of this court.
So you have not filed the additional affidavit.
Even though I have filed the additional affidavit, I have mentioned only 4 stretches of road, Lordship.
So you want to file
Another
another affidavit?
additional affidavit, Lordship.
Okay. We'll allow, in the meantime, you'll see. Heard Ms. Rosalind Elmar, learned counsel for the petitioner, who submits that in addition to the additional affidavit filed by the petitioner on 31/07/2025, she may be allowed to file another additional affidavit to highlight the condition of the roads already mentioned in the said additional affidavit dated 31/07/2025. Praise the Lord. This is the matter after 3 weeks. The presence of Ms. Lal Nundui, learned government advocate for respondents number
1 to 5, Your Lordship.
1 to 5, Ms. Zaram Sangpui, learned CGC for respondent number 6, and Mr. Samuel L. Sangte, learned standing counsel for NHIDCL, respondents number 7 is noted. The learned counsels, the learned, so instead of is noted, okay, who have all prayed is noted, full stop. Okay, the learned counsels for the respondents have also prayed for further time to file the to file their affidavits. In view of the above, list after 3 weeks.
Obliged, Lordship.
Item 5.
Yes,
Lordship, regarding respondent number 2, if I'm not mistaken, AD card has now returned, has served.
ID card returned?
Yes, Your Lordship. And the online tracking, I think, also has been done, and it's remarked
Yes.
received, Your Lordship. So
Now, no one is representing respondent number 2.
number 2, as of now, my lord, there is no representation.
We'll give him one chance to be represented. And then the next court date, if he remains unrepresented, then maybe we'll have to
In
proceed.
the meantime, Your Lordships, we haven't received the appeal memo.
Yes, apologies, Your Lordship. I was directed to furnish copy, my
okay.
lord, that due to miscommunication within my office, my lord, that is not, we'll do it during course of the day.
Yes. Mr. C. Zoram Chana, learned counsel for the appellant is present, along with Mr. J. Mal Somzwala Bansong, learned counsel for respondent number 1. It is seen that AD card from respondent number 2 is returned. However, is returned after service of notice. However, none appeared for respondent number 2. We find it appropriate to give a chance for respondent number 2 to be duly represented. Stop. Meanwhile, the learned counsel for the appellant is to furnish requisite copies of the appeal memo to the learned counsel for respondent number 1. List after 3 weeks.
2 weeks, my lord.
Okay, list after the ensuing vacation.
My lord.
Then let's see.
Obliged.
Item 6.
Lordship, I'm appearing on behalf of my senior for respondent number 6, the NPSC, my lord. And we've recently just received our parallelized comments, my lord. So we'll be filing our counter affidavit within this week.
You're appearing for on behalf of Mr. J.C. Lalman Sanga, is it?
Yes, my lord.
That is respondent number 6, MPSC.
Okay, we'll have to wait for the counter affidavits, isn't it?
Yes, my lord.
Mr. Victor L. Ralte, learned counsel for the petitioner is present, along with Miss Daphne, is it?
Yes, my lord. Definitely.
Lalshwai Kwangi, learned counsel, appearing on behalf of her senior, Mr. J.C. Lalnun Sanga, learned standing counsel, MPSC, who submits that they may be given further time to file the counter affidavit.
In the meanwhile, I'll be also filing my rejoinder against the state affidavit.
Okay. Ms. Vaneswamy, learned government advocate for the state respondents is present and submits that they have already filed their counter affidavit. Full stop. Then the learned counsel for the petitioner has prayed for time to file his rejoinder affidavit to the counter affidavit, has prayed for further time, okay, to file his rejoinder affidavit to the counter affidavit already filed by the state respondents. Full stop. In view of the above, list the matter after the ensuing vacations. Yes.
Item 7.
Lordships, I appear for the petitioner. My lords, the counters have not yet come. And finally, my lords, the respondent 7, the private respondent, I believe they've engaged the council now.
We're going to file on behalf of.
Okay, you need time. Okay, you're going to represent the private respondent.
Yes.
Number
7.
7, who was also appointed, who was also promoted, isn't it?
Yes, yes.
Then you'll have to file your counter fast because your promotion is subject to the outcome of the instant writ petition. Okay, so you cannot delay the matter.
My lords, today there's a subsisting illegality. Your lordships has seen the rules. So my lords,
No, whether that it's a different matter, whether it's illegal or not.
My
But
lord, the
since his now very recent promotion is subject to the outcome of the writ petition, you should file your counter soon, isn't it? Don't have the matter pending. Yes.
Yes, Your Lordship, I'm representing the respondent number 1 to 4, and I'm seeking 3 weeks' time.
Okay, 3 weeks time while you
Your
chief,
I'm appearing on behalf of my senior for the MPSC as well, my lord. And in this case, my lord, as per the instructions we have received, we will not be contesting, my lord.
my lords, I
We will not
believe
be filing
you'll not be filing any counter?
Yes, ma'am.
Okay, fine. Heard Mr. Jordan Broming Thanga, learned counsel for the petitioner, along with Mr. Vantu, learned counsel, who submits that he will be, learned counsel, who submits that he will be representing the private respondent number
7.
7. Full stop. Then, Ms. Vanesiami, learned government advocate for state respondents number
1 to 5.
1 to 5.
No, 1, 2, 3, 4, and 6.
State 1 to 6. Okay. And Miss
Definitely Shortlangi, my lord.
Daphne is also appearing on behalf of her senior, Mr. J.C. Lilmantluanga, learned standing counsel for respondent number
5.
5 are also present. Full stop. The learned counsels for respondents, the private respondent number 7 and the government advocate has prayed for 3 weeks' time to file their counter affidavit, while the standing counsel for the standing counsel for respondent number so and so 5 submits that they will not be filing their counter affidavit. In view of the above, list the matter after 3 weeks.
Obliged.
Orders, item 8.
My lord, this IA is an application for condonation of 583 days delay for filing with appeal for challenging the order dated 21/7/2023 passing CS, passing WPC 194 of 2016, my lord. We are late for filing our appeal for 583 days. However, the delay was not caused due to negligence on the part of the applicant. However, that was caused due to unavoidable circumstances that should be followed by Union of India for processing the case for filing, my lord. The judge, we are aggrieved with the judgment and order dated 21/7/2023, passing WPC 194 of 2016, my lord. The judgment at page Roman number 1. The relevant portion is at page 31, my lord. Roman number 31. If I may read, my lord, thus, upon due consideration of the matter in its entirety, I find merit in the writ petition, and accordingly, the Deputy Commissioner cum District Collector, Mamit, District Mamit, respondent number 2, is directed to calculate the salarium and interest payable the petitioner under Section 23, 1A and 2 of the L Act, and interest for delayed payment entitled to the petitioner under Section 34 of the L Act within a period of 1 month from the date of receipt of certified copy of this order. Thereafter, the respondent number 2 shall forward the same to the respondent number 5 and 6 for arranging the requisite fund. The respondent number 5 and 6, upon the receipt of the same within a period of 3 months, shall deposit the entire amount, the entire awarded amount awarded by by the collector, that is 1,499,16469, and the assessment made towards solatium in interest and for the delayed payment before the respondent number 2N, which shall then be dispersed to the landowner petitioner as per their respective share without delay. Within the above observation and direction, the writ petition stand disposed of parties to bear their own costs. My lord, in this award, there are 2 awards at the same time. One award is for online damage, that is for construction of road, border fencing road, my lord. However, the other one award is the present case is deemed damage.
Additional award.
Deemed damage. Same award, two award was issued at the same time. What is for online damage? That online damage award already been paid. However, this award has been prepared by the state government for deemed damage. Deemed damage means that not constructed on their land. However, due to construction, the petitioner are unable to utilize their land according to the award. However, as per our opinion, that is disputed question of facts has been involved. This should be decided by the civil court by way of evidence only, because deemed damage is not a part of the acquisition, my lord. That is why we are aggrieved with. In the meantime, the part of award had already been paid to the petitioner. That is why we are willing to, we are aggrieved with this judgment and order, and intended to file, decided to file appeal. However, my ground is that
Why the delay of more than
Yes.
1 year? If you
yes,
are aggrieved.
583 days has been delayed. My lord,
Judgment was dated 21/07,
yes, my lord.
2023, huh? Yes.
Then,
What happened?
my lord, the main reason is that even it-
So we will just read it out. This 7.
My lord, in pursuance to the judgment and order passed by the landed single judge, my lord, the deputy commissioner Mamit prepare calculation, that is a para 6 of my appeal, my application, my lord. Then the same has been forwarded.
Condonation will see this was, no? Whether there are grounds for condonation.
The same has
Yes.
been forwarded to NBCC, National Building Construction Company, that is our agency for construction of the same. Then para 7, my lord.
Para
And-
7,
Yes, at para 7, the NBCC Limited approached the director BM2, Border Management 3, MHA, Government of India, New Delhi, with request to deposit the said amount within a stipulated time with the state government to honor the order of Honorable High Court Bench, Guwahati High Court. My lord, that letter has been sent to the ministry via letter dated 11/9/2023. Then at para 8, my lord, thus it is stated that MHAB Border Management 1 Division, white letter dated 29/2023, informed that as desired by competent authority. Yes, my lord, here, as desired by competent authority, BSF is requested to file SLP writ appeal against the High Court Guwahati Aizol bench
So
order.
appeal, filing of appeal was decided on
Yeah,
29.
on 29, my lord, within a time. Whenever they receive a compensation assessed by the state government, and the same has been forwarded by NPCC to the MHA, they decided to file appeal on 29/2023. However, there is some cut short of my long submission, my lord. Even the MHA decided to file appeal. However, they trying to use the BSF to file appeal. In the meantime, BSF is not a party in the writ petition. However, all the construction proceeding has been under vigilance of BSF, my lord. However, in the main writ petition, BSF is not a party. That is why, even though they are trying to convey the BSF to file writ appeal, however, there is some communication between BSF and MHA in
So
between.
where's the communication?
Yes, my lord. From
So when did they inform the BSF to file the appeal?
yes, my lord. Then from para.
They informed BSF to
Yes.
file and appeal on which date?
106, page number 106, my lord.
That's the
Here,
communication.
Yes, my lord. Here the letter issued by the ministry, my lord. That is dated, issued on 29/2023. If I may read, my lord, subject payment of solatium in interest in the matter of WPC number 194 of 2016, filed by Sri Chowkunga and 256 others versus State of Mizoram 4 others in the High Court of Assam, Nagaland, Mizoram, and Arunachal Pradesh, Aizol bench. Regards. Reference is invited to NBCC letter dated 11/9/2023. Number 2, the undersigned is directed to inform that this ministry white letter dated 20 September 2023 has been directed BSF to file SLP/writ appeal against High Court order Aizol bench dated 21st July 2023,
Right, who is subject writ petition was disposed of by the Honorable Court. Number 3, further, it is informed that decision for making payment will be taken by this ministry after finalization of SLP/writ petition, writ appeal being filed by BSF. The number 4, NBCC is requested to provide necessary assistance or any other relevant information to BSF, which is required by BSF for filing of SLP writ appeal in the matter, my lord. Since they decided to file appeal within a time. However, due to misunderstanding, miscommunication between the MHA and BSF, some delay has been occurs, my lord. Yeah, however, BSF was not a party in the WPC. Then para 9 to 19. Para 9 to 19 of my application is for searching out of the relevant document by BSF first. Then they took some time for searching, because since they are not a party, they are trying to search out the relevant document from NBCC and from the other sources. Then that para in short, my lord, para 9 to 19 is for searching document from the relevant document for filing appeal. Then para 20 of my affidavit, my application.
Yes.
Here, thereafter, the MHA BM Division White Letter dated 7/5/2024 intimated that NBCC had already been requested to provide necessary, that on 7/5/2024, MHA intimated that NBCC had already been requested to provide necessary assistance or any other relevant information to BSF, which is required by BSF for filing SLP/writ appeal in the matter. White letter dated 29/2023. At para 21, that on 16/5/2024, NBCC White their letter dated 16/5/2024 requested to provide the status of filing SLP in the case and intimated to the contact Sri C.G. Shamal of NPCC to for any necessary assistance required and share their contact detail. Then para 20 to 21 of my application is communication with NBCC by the BSF for relating document, my lord. 21. 2021.
20 and 21, huh? This is communication between
BSF and
NBCC and
NBCC.
BSF.
Yeah.
Okay.
That is a communication letter. That we enclose all that communication letter for your kind perusal, my lord.
So just
Then
show
on
us the
23.
nature of the communication so that we don't have to see later. Annexure 21. Is it?
Annexure 3, I already read out. Then Annexure 6, page 109. That is the letter to the General Manager NBCC 109. That is the letter addressed to the General Manager NBCC issued by
by
2IC BSF. In this regard, it is informed you that a copy of judgment and order CAV against court case number WPC 194 of 2016.
It's okay. So they've asked, isn't it? They've asked for
Yes.
what? Documents. Okay. Then
Thereafter, my lord, the next letter,
again by BSF.
yes. The next is translation copy, type copy.
So here they says that they do not have any this thing. There is no Copy of the judgment was received by BSF, isn't it?
Yes, my lord.
Brief history concerning the case, huh?
Then, para 23.
So basically, the BSF, they were informed, judgment was also received.
My lord,
So
they
they
received,
have asked for the brief history of the case,
the
BSF.
judgment alone is received within the time from CGC.
Huh.
After.
So BSF also received,
Yeah,
but they want a history.
Yes, they want a history of the case because since they are not part in the case, they want to know the facts of the case. Even there are not custodian of the case report. Then at para 23 of my affidavit, they approach CGC along with brief detail of obtaining legal advice. Then, my lord, the CGC render her opinion at page 128. 128 is the letter to CGC first. The 38 Battalion BSF sent letter to CGC. Then 133 is the opinion of CGC, my lord.
This is dated 2nd June.
14 June 2024.
So it
Here,
is,
the CGC informed them that since the BSF is not a party in the case, they cannot file appeal. Then every related document has been sent to the CGC to MHA by CGC at the relevant time. Then if they are aggrieved with the judgment and order, the MHA themselves could file appeal. However, even the SLP is not appropriate for the same. They have to file writ appeal before division bench. That is the advice to give by the CGC. That was on 14 June 2024.
so it is 14th June. Judgment was in 2023. So all this communication, you have to show the delay. When did you, okay, 2nd June it was, the BSF had asked for your opinion. So on 14th June, you were able to inform them. Okay.
Then file is going on table to table, and they pursue the matter as per their.
So once the BSF got to know that they were not the
Yes.
party, then what happened? What did they do?
Then that is why they are trying to convince the MHA to file appeal from their ends. However, they are unable to convince.
So
That's
whose fault
took
is
for a
it?
long time. That is.
Your fault? Isn't it? So once MHA got to know that, okay, BSF is not involved, then they should have taken immediate action, isn't it? So 135 is the information given by BSF to MHA,
Yeah.
isn't it?
There are so
That-
many communication.
So how do you explain the delay made by the, because you are representing the MHA?
Yes, my lord. I'm also representing MHA.
Ah.
Then I render my opinion. My opinion has been sent to MHA.
Ah.
However, the MHA are not understanding at that relevant time. However, after the legal advisor of the MHA decided to file appeal in appropriate forum, they decided to file appeal. Then it's took.
So that
Much
part you have
time.
to explain properly. So let's see the communications concerning that. So when did you inform the MHA that the BSF is not
My lord, I'm not informing directly because since I render my opinion has been sent to
Okay, so
table
when
to
did
table.
BSF inform the MHA? Which
Yes, my
the
lord.
letter dated?
Then the MHA, the BSF,
When did
this
they got to know that
sector
BSF is?
headquarter BSF Aizawl sent to the higher headquarter, then higher headquarter sent to the next higher headquarter, then the
Okay,
board.
so when did MHA get to know that BSF is not involved
My lord,
in anything? Do you have any documents?
page 46.
Because we have to see whether the
Yes, madam.
MHA was negligent, isn't it? In filing the appeal since you're the MHA. Before they were under the impression that BSF was involved. Okay, that may be some excuse, whatever, maybe we can consider that. But once MHA got to know that, okay, it's not BSF, then what are the steps taken? And when did they get to know?
That is a signal, by way of a signal form. My lord, in the letter was sent to the CCC, that is at page 156. In this letter, they stated about
Oh,
the
so
MHA
Home
letter.
Affairs got to know. Okay. This is on 14th October.
They stated the letter of MHA, 9 September 2024, but not enclosed, my lord. Again, directed to file BSF to file SLP. Even though they have knowledge about the BSF has no entitled to file appeal, however, they trying to compel to file. However, later on, lastly, as far as my knowledge is concerned, it may be 188 page. Prior to that.
So again, you involved the BSF. This is December.
My lord, because this construction has been done within the area of BSF, that construction has been done with the vigilance of, under the vigilance of BSF, with the NPCC. Then MHE is only a nodal ministry. However, since they are not party in the case, they have no knowledge about the case. That is the problem. Now, in page 185, my lord, That is the letter issued by 191 Battalion BSF. And on the next page, 186. In this case, okay, no. Here, even though there are not a specific acceptance of the MHA for filing appeal in their name. However, at page 186, my lord, one of their ASGI Sanjeev Kumar is coming to CGC office for discuss with this. At that time, the CGC was handed over his drafted appeal for filing. It could be presumed that at this time, they decided to file appeal in their name, my lord.
So
Then the CGC was handed over drafted appeal filed by Sanjeev Kumar ASGI, my lord. Then, however, there is some defect which is not as per the Guwahati High Court rules. That is why the CGC asks soft copy of that drafted appeal. After that, she make
where's
correction.
that? Where's all that?
Yes, my lord.
We have a
Signal
document.
dated,
Page, yes, the mentioned page.
at para 52, my lord, I stated regarding the
Okay.
um,
So you asked them verbally.
yes, verbally. I asked them verbally.
Okay, okay.
52 to 57. At 58, my lord, on 27/11/2024, 38 Battalion BSF via their letter dated 27/11/2024 provided a draft writ appeal along with annexes to CGC Aizol bench with request to prepare a fair draft writ appeal and return the same for obtaining approval and signature of competent authority. After approval of competent authority, the same would be sent to office for filing the same before division bench of Guwahati High Court Aizol bench. That is annexure, marked as annexure, my lord. Then on 29, that on 6/12/2024, Frontier Headquarters BSF M and C via letter via their signal dated 6/12/2024 forwarded a copy of letter in which CGC asked to provide all the document queries to BFHQ BSF New Delhi. Then para 60, that on 30/12/2024, Sector Headquarter BSF Aizol via their signal letter dated 13/12/2024 directed 38 Battalion BSF to provide soft copy of present drafted writ appeal to CGC Aizol bench as asked by her via her letter number so and so dated 2/12/2024 under intimation to Sector Headquarter BSF Aizol along with reason why the appeal has been filed after a lapse of more than 1 year and day-to-day explanation or sufficient ground required for convincing the court by 16 December 2024 without fail. The CGC also intimated that the court will remain closed due to winter holiday. In the meantime, the winter holiday has coming from nearly 1 month. Then at para 61, that on 13/12/2024, 38 Battalion BSF vice signal dated 13/12/2024 intimated Sector Headquarter BSF that on 30/12/2024, Sri S.R. Baiwa, Commandant of 38 Battalion BSF, along with Sri so and so Commandant, BSF visited at the chamber of CGC Aizawl to discuss with the matter, where CGC Aizawl intimated the draft appeal received from 38 Battalion BSF White letter so and so dated 27/11/2024 was not as per the format required, and also requested to provide a soft copy of the draft writ appeal for correction and further necessary action. 62. That on 15/12/2024, Sector Headquarters BSF Aizawl by their signal dated 15/12/2024 intimated 38 Battalion, now 191 Battalion BSF, that a draft letter has been prepared on the subject matter to be attested by the Commandant of 38 Battalion, now 131 Battalion BSF, and sent back to Sector Headquarters BSF Aizawl by on 15/12/2024. The same was attested by Commandant of 131 Battalion BSF and sent back to Sector Headquarters BSF Aizawl by 191 Battalion BSF. White letter dated 15/12/2024. Parat 63. That on 17/12/2024, 191 Battalion BSF White their signal dated 17/12/2024 informed Sector Headquarters BSF Aizawl that the soft copy of Chronicle Order of Action in the said case has been forwarded to their headquarters along with hard copy of the same. White 191 Battalion BSF letter dated 17/12/2024 as asked by Sector Headquarters BSF Aizawl. 64. That on 19/12/2024, 191 Battalion BSF White their signal letter dated 19/12/2024 in reply to Sector Headquarters BSF Aizawl signal dated 13/12/2024 informed that the representative from 191 Battalion visited office of CGC and hand over the soft copy of the present writ appeal to the
So you're
CGC.
showing that
Then,
steps were taken, isn't
Yes.
it, on 1912?
Yes.
Then again on 2012 also, you pursued 2012 again, then 23rd 12.
Then it's 65, my
Steps
lord.
were taken.
On 20/12/2024, CGC Aizawl White, her letter dated 20/12.
Anyway, what you are trying to show
forwarded-
is that there was no negligence.
Yes,
So
there is
on
no any negligence.
2012 same, so 23rd also some communication was
Yes.
there. Okay, then on 21st 12 also some communication is
Yes,
there.
forwarded draft appeal to 191. However, also intimated that don't availability
On
of
Christmas
proper
Day
documents
also,
for
25/12.
condonation of delay. But at that time, after draft has been prepared, however, we have to prepare again condonation of delay.
Oh.
That is why the CGC
So
request
how
to
many days
furnish.
did you take for condonation of preparing the
That is a
condonation of
case,
this letter?
Para 65,
this
my lord, the
affidavit.
CGC informed.
Ah.
Then even the draft appeal had already been prepared, however, condonation of delay has to be prepared. In the meantime, the CVC was not furnished the reason why delay has been caused in orderly. That is why I request them to provide. Then that took some another time for that. Then after finalization of that, we file appeal, however.
So how
we
long
may-
did you take to prepare the condonation of delay application?
My lord, at my application para 73, that on 28/12/2024, 191 Battalion BSF informed Sector Headquarters
So
BSF
28/12/2024 to
info
the present.
to the
When did
Sector
you finally
Headquarters.
file your condonation on? When did you file your condonation of delay application?
My lord, application on 27/2/2024. However, the court will be reopened only on 13/1/2025 due to winter vacation. Then on 30/12/2024, Frontier Headquarters BSF White Signal Letter 30/12/2024 intimated Headquarters DG BSF that the draft interlocutory application was forwarded for sharing with MHA for vetting and approval. After that, we send them back for vetting. Then that on 30/12/2024, the headquarter BSF MNC white letter 30/12/2024 informed headquarter DGBS if that draft interlocutory application was shared with MHA for vetting and approval. After approval, MHA might be requested to share the same with CGC.
From 28/12/2024 to 20/03/2025. That was just for preparing the
Yes, my lord.
continuation of delay application because of non-availability of documents, is it?
Then they return,
You're reading from para?
at para 83 of my application. That on 28/1/2025, 191 Battalion White Signal, dated 28/1/2025, informed Sector Headquarters BSF Aizawl that the special representative visited the office of CGC Aizawl bench on 28/1/2025 to hand over the fair writ appeal along with interlocutory application, and the same was returned by CGC after thorough perusal. CGC so-and-so mark out certain observation in the format and document that need to rectify, same being sent to FHQ BSF.
So para
For further,
73 to
yes.
para 102,
Yes.
para 73 to para 102
Yes.
is the explanation.
Yes,
For
explanation.
the delay in filing the IA.
Yes, my lord. Then every submission has been supported by document. Then I enclose it all. Then there is no negligence, willful negligence. However, we are late, 853 days for filing
Steps were
this appeal.
taken after 2 days, 3 days. Sometimes there is 4 days. After 1 week, something 2 days.
In the meantime, summer vacation and winter vacation are in the meantime, my lord. We are
Winter
not
vacation
counting
is from which date?
Vacation. Court reopen only 13.
2024 is from which period?
In the
16th.
month of, in the month of October, 1 week.
October is only 1 week.
1 week, December, 1 month.
16, 12, 2025, 2024 to maybe 11, 1, 2025.
2025.
Not 1 month, less than 1 month. So between this period, your application was not ready anyways. You were still running around. It was not ready on 16/12 to be filed.
Yes, my lord.
Vacation
From
or
my
no
side, I am
vacation,
ready.
vacation or no vacation won't make any difference because even if the court had remained open, you were still not ready.
However, that was not yet returned to CGC also, my lord. Even the
See,
CGC
during the vacation, had it been ready on 15/12/2024, but you could not file because of the winter vacations,
Yes.
that's an excuse. But from your communication between 16/12/2024 and 11/1/2025, it was not ready anyways. Even if the court was
because
open.
they come back with interlocutory application, but there is something wrong. Then
So
for
you were not
clarification,
ready
send it
anyways.
back.
Even if the court, even if there was no vacation,
Yes.
you were not ready with the IA anyways,
Yes,
isn't
my
it?
lord, right.
So vacation cannot be taken. as
Yes,
an
yes, yes. My lord, when it come back along with the IA, my lord, however, some another date has been gone, then they have
So
to
you were
prepare
running
first,
around during the
within
vacations
that,
also.
that period. That is why we are late. Then that is not willful negligence, and there is no any.
You're showing how much you have been running around, isn't it?
yes, ma'am.
Almost every day, communication up and down.
Yes, my lord.
But I think some of the communications, if they or you had been more diligent, would not have been required.
My lord, I have two citations in this regard. 1998, 7 SCC 123, para 9 through 12. 1998, 7 SCC 123.
1998. Seven SCC
Oh,
123.
online.
Is this the para?
Para 9 through 12.
What?
In online,
9 to 12. Ah.
at para 9, my lord, if I may, it is geometric that condonation of delay is a matter of discretion of the court. Section 5 of Limitation Act does not say that such discretion can be exercised only if the delay is within a certain limit. Length of delay is no matter. Acceptability of the explanation is the only criterion. Some delay of the shortest range may be uncondonable due to one of acceptable explanation, whereas in certain other cases, delay of very long range can be condoned, as the explanation thereof is satisfactorily. Once the court accepts the explanation as sufficient, it is the result of positive exercise of discretion, and normally the superior of the court should not be disturbed such finding, much less in revisional jurisdiction, unless the exercise of discretion was on wholly untenable grounds for arbitrarily or perverse. But it is a different matter when the first court refused to condone delay. In such case, the superior court would be free to consider the cause shown for delay afresh, and it is open for such superior court to come with its own finding, even untrammeled by the conclusion of the lower court. 10. The reason for such different stance is thus the primary function of the court is to adjudicate the dispute between the parties and to advance substantial justice. The time limited fixed for approaching the court is different situation is not because of the expiry of such time. A bad cause would transform into good cause. 11. Rule of limitation are not meant to destroy the right of the parties. They are meant to see that parties do not resort to dilatory tactic but seek the remedy promptly. The object of providing the legal remedy is to repair the damage caused by the reason of legal injury. The law of limitation fixes the lifespan for such legal remedy for the redress of the legal injury to so suffered. Time is precious, and waste time would never revisit. During the effects of time, new cause would sprout out, necessitating newer person to seek legal remedy by approaching the court. So a lifespan must be fixed for each unending uncertainty and consequential anarchy. The law of limitation is thus founded on public policy. It is enshrined in the maximum interest republicate absit finis litem. As it is general welfare, it is general welfare that appeared to put for litigation. Rules of limitation are not meant to destroy the right of the parties. They are meant to see that parties do not resort to dilatory tactic but seek the remedy promptly. The idea is that every legal remedy must be kept alive for legislative fixed period of time. 12. A court knows that refusal to condone delay would result in foreclosing a suitor from putting forth in cause. There is no presumption that delay in approaching the court is always deliberate. The court has held that there was sufficient cause under Section 5 of the Limitation Act should receive a liberal construction as to advance substantial justice by so and so. This is one of my citation. That is discretionary power of the higher court, my lord. Then another citation is 1996 3 SCC 132, para 11. Yeah, if I may read, my lord, it is notorious and common knowledge that delay is more than 60% of the cases filed in the court, be it by private party or the state, are barred by limitation, and this courts generally adopt liberal approach in condonation of delay, finding somewhat sufficient cause to decide the appeal on merit. It is equally common knowledge that litigants, including the state, are accorded the same treatment, and the law is administered in the even-handed manner. When the state is an applicant praying for condonation of delay, it is common knowledge that on account of impersonal machinery and the inherited bureaucratic methodology imbued with the note-making, file posing, and passing on the buck, equals delay on the part of the state is less difficult to understand, through more difficult to approve. But the state respondent collective cause of community, it is axiomatic that decisions are taken by the officers, agency, proverbially a slow pace, and encumbered process of pushing the file from table to table and keeping it on table for considerable time, causing delay, intentional or otherwise. It is routine. Considerable delay or procedural red tape in the process of their making decision is common features. Therefore, certain amount of latitude is not impermissible. If the appeal brought by the state are lost for such default, no person is individually affected, but what in the ultimate analysis suffers is public interest. The expression sufficient cause should therefore be considered with pragmatic, injustice-oriented approach rather than the technical detection of such cause. For explaining everyday's delay, the factors which are peculiar to be and characteristic of functioning the government condition would be cognizant to the required adoption of pragmatic approach in justice-oriented process. The court should decide the matter on merit unless the case is hopelessly without merit. No separate standard to determine the cost laid by the state vis-a-vis private litigant could be appropriate. Levels should constitute legal cell to examine the cases whether any legal principle are involved for decision by the court or whether the case required adjustment and should be authorized the officer to take a decision or give appropriate permission for settlement. In the event of decision to file appeal, needed prompt action should be pursued by the officer responsible to file the appeal, and he should be made personally responsible for lapses, if any. Equally, the state cannot be put on the same footing as individual. The individual would always be quick in taking the decision where he would pursue the remedy by way of appeal or application, since he is a person legally injured, where the state is impersonal machinery, working through each officer or servant. Consider from the person, it must be held that the delay so and so is condoned, my lord. That is my submission. Then I pray this honorable court that to allow my to condone my delay. Oblige.
Mayor, please, Lordship. To begin with, my lord, I would like to take your lordship to Section 117 of the Limitation Act. The Limitation Act 1963 has been made applicable to the whole of India except the state of Jammu and Kashmir. My lord, as per section 117 of the Limitation Act, the appeal period is 30 days. 30 days, not 90, my lord. Because from a degree or order of any high court to the same court, since the impugned judgment and order passed by the Honorable Single Bench is filed before the President Honorable Division Bench, my lord. So the appeal period is 30 days. My lord, I have prepared list of dates. The same may be furnished to your lordship.
So the learned CGC is saying that it is 90 days. The, how have you calculated 90?
No, 30,
30.
my lord. 30.
30?
30 days, yes, my lord.
You say it's 30, huh? So it's okay, huh? 30 days, huh? Yes, okay.
My lord. I'm saying I'm reading this provision because 30 days only, and they have taken more than 500 days in filing the present appeal.
Okay, I thought there was some dispute over the number of days, huh? Anyways,
30
huh?
days is to be kept in mind, my lord. My lord, as per my list of dates prepared, the judgment and order, a copy of the impugned judgment and order was passed on 21/7/2023. And the said copy was received by the appellant on 24/7/2023. And the appellants have decided to file an appeal against the impugned judgment and order on 29/2023, September 20, 2023. That is, as per the annexure at page 106 of the application, later decision was made by this annexure 3 at page 106, my lord. Decision
Yes, she
was
had
made
also, her
to
CGC
file an
also
appeal. Yes, ma'am.
shown that letter to us,
Yes, ma'am.
yes.
That was on September 20, 2023. And thereafter, my lord, appellant approached CGC on 2nd January 2024. That means they took 113 days to approach the CGC. I don't know why they took this long for approaching after making the decision to file an appeal.
So, but this period between 29/2023 and 02/01/2024, I think it has been explained by her
My lord,
that
I'll
BSF,
come to that
whatever,
point, my lord. How come they took this long? Knowing the fact that the appeal period is 30 days only. Because this Limitation Act has been made applicable to the whole of India since 1961, my lord. 63,
63.
my lord. So, Union of India, of all the people, of all the persons, my lord, knows very well the appeal period is 30 days because this is not the first case. They have had many cases, appeal, filing, sort of, my lord.
So you're saying we should not consider the explanation given by
My
her
lord.
between 29/2023
Yes,
and
my lord.
02.
Yes, my
She's given a long explanation.
Yes, my lord. And apart from that, I have a ruling to
Okay.
rely upon of the Supreme Court ruling is saying that interdepartmental correspondence cannot determine sufficient cause for condonation of delay. I'm coming to that, my lord.
Okay.
Interdepartmental correspondence and processing of the matter to enable the department to file their instant petition is not considered to be sufficient cause to explain the delay. And my lord, thereafter, legal opinion was given by the CGC on 14 June 2024. That is at page 133 of the instant application. And thereafter, on 5th August 2024, CGC wrote to the BSF commandant, if respondent number 5 and 6 were aggrieved, they should file appeal before division bench of the Guwahati High Court. That is to be found at page 143 of the instant application, my lord. And although they have taken decision to file an appeal on 20 September 2023, they have applied for certified true copy of the impugned judgment in order on 15 January 2025 only, my lord. How many days have gone by? Can be counted, my lord. From 20 September 2023, certified true copy was applied for only on 15 January 2025, my lord. And without any explanation as to why they have applied for CTC only thereafter. There is no explanation to that effect, my lord. And I have a ruling of the coordinate bench, division bench of this honorable court, my lord, to be relied upon in this connection. And they have filed the present appeal along with the application for condonation of delay only on 20 March 2025. Thereby, a delay of 583 days to be condoned by this honorable court without any sufficient cause, my lord. So my submission to your lordship is, there is no sufficient cause to condone the delay, the inordinate delay of 583 days. My first authority, the Supreme Court ruling I'm relying upon, as far as the interdepartmental correspondence and processing of the matter to enable the department to file is not sufficient cause. In the ruling, Union of India and others versus Tata Yodogawa Limited and another, reported in 2015, volume 9, page 102, para 2, starting from para 2. Well, I'm reading, it's not very long. I'm reading from para 2. I'm reading from para 2 with lordship permission. It appears, according to the office report on limitation, that the special leave petition is delayed by 51 days. Here, 51 days delay is not being condoned by the Supreme Court, my lord. The application for condonation of delay was filed on behalf of the petitioners, stating therein that due to interdepartmental correspondence and processing of the matter to enable the department to file the instant petition. Para 3, the list of dates in the application for condonation of delay gives interesting reading as follows. I'm not reading the whole thing. The dates is given, various dates are given there, a date of receipt of certified copy of the High Court of Patna judgment, and so on and so forth and so forth. So on and so forth, my lord. So many dates are given there. And para 4, from 26/12/1986 to 10/2/1987, and from 6/3/1987 to 24/3/1987. There is no cogent and possible explanation. It may be mentioned that the special leave petition was actually filed on 23/3/1987. There is no whisper to explain what legal problems in filing the special leave petition arose. It appears to us that no attempt has been made to explain this delay. In the view of the matter, we gave further opportunity to the petitioners to file additional affidavit explaining the cause, if any, for this delay. It is at para 5. it is further stated in the rejoinder affidavit to the counter affidavit on behalf of the respondent that such delay is always beyond the control of, especially in government matters, as the file has to be routed through several sections of the department. We are aware of the fact that the government, being impersonal, takes longer time than the private bodies or the individuals. Even giving that latitude, there must be some way or attempt to explain the cause for such delay. As stated from the facts narrated herein above, there is no sufficient cause to explain the delay. Hence, the application for condonation of delay is dismissed. This is my first ruling, my lord. And as far as the applying for certificate to copy, I am relying upon one judgment of the division bench of this court. In the case of State of Assam and others versus Gita Rani Kalita and another, reported in 2017, volume 2, GLP, page 1190. Para 9 is the relevant para, my lord.
Actually, this is also available in SCC online, GLT. It's here. Anyways.
I'm reading
119,
para 9.
page?
Page 1193. The relevant para is found at page 1193. Para 9. Para 9 with lots of permission of
Yes,
reading.
yes, please.
The certified copy of the impugned order dated 6/1/2015, annexed with the memo of appeal, reveals that application for sale was made as late as on 25/5/2016. That is, after 1 year, 4 months. No explanation is given why application for obtaining certified copy was not made within reasonable time. More particularly, when the order was passed in the presence of learned counsel for the applicants. My lord, similarly, the the impugned judgment and order was also passed in presence of the rival counsels, and it was the same CGC who appeared before the single bench is the one who filed the present appeal for and on behalf of the Union of India. And there is no explanation as to why the CTC, certified true copy of the impugned judgment and order, was applied for during the in the reasonable time, within the reasonable time. They have not explained anyway. However, it was applied, this CTC was applied for on 15 January 2025, my lord. The judgment date is 21 July 2023. And certificate true copy was applied for on 15 January 2025. In fact, they have decided to file an appeal against the impugned judgment and order on 20 September 2023, my lord. And there is no explanation why they have applied for the CTC of the impugned judgment and order at the very late stage, only in the year 2025, beginning, my lord. And this judgment, which I have pointed out,
Yes.
of the division bench, dismissed, rejected the appeal filed by the petitioner on this ground alone. And one more judgment I would like to place before Lordship is, this judgment is quite common to all of us. Postmaster General and others versus Living Media India Limited and another, reported in 2012, volume 3, SCC, page 563. Para 27 onwards, my lord, I'm reading. Para 27, with your lordship permission, I'm reading. It is not in dispute that the person concerned were well aware or conversant with the issues involved, including the prescribed period of limitation for taking up the matter by way of filing a special leave petition in this court. They cannot claim that they have a separate period of limitation when the department was possessed with competent persons familiar with court proceedings. In the absence of plausible and acceptable explanation, we are posing a question whether delay is to be condoned mechanically merely because the government or a wing of the government is a party before us. Para 28. Though we are conscious of the fact that in a matter of condonation of delay, when there was no gross negligence or deliberate inaction or lack of bona fides, a liberal concession has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. Para 29, my lord, in our view, it is the right time to inform all the government bodies, their agencies, and instrumentalities that unless they have reasonable and acceptable explanation for the delay and there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending for several months, years, due to considerable degree of procedural red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government departments. The law shelters everyone under the same light and should not be cruel for the benefit of a few. With that, I conclude my submission to your lordship, my lord. And taking into account the three judgments which I have relied upon, and knowing the fact that the copy of judgment was received by the party, by the appellant in time, and decision was made thereafter during the period of appeal, and they took too much of time without caring, without having any respect for the law and the court. They have filed the present appeal after more than 500 days delay, expecting that the delay would be casually condoned because of the
Yes.
lame excuse they have made in their application, my lord, which are to be rejected. My prayer to your lordship is to reject and dismiss the application filed for condonation of delay of 583 days.
Yes. Anything? That's it? We'll consider the matter.
No, my lord, because all best effort has been,
Pardon?
our effort has been paid for filing this appeal, then we have not.
So you've
made
made,
anything.
yes, you've made, so you've given an
Yes, ma'am.
explanation, isn't it? Heard Miss Zairam Sangui, learned counsel for the applicant slash appellants, along with Mr. L.H. Lianchulu, learned senior counsel, assisted by Ms. Ruth so learned counsel. On hearing both the parties, the matter is kept for consideration.
Obliged.
Oblige.
Item 14,